I'm going to talk about the Crucible, really problems with the way the adversarial criminal trial deals with expert opinion evidence. And this comes out of a range of studies that I've undertaken with a range of people from various professional backgrounds. And a lot of it's been developed from empirical work where I've been watching court cases in New South Wales and elsewhere, including South Australia. Now, one of the things I think, one of the things we're going to do today is try and synthesise some of the material to give a broad overview, and by way of caveat, I'm going to be painting in broad brushstrokes. I think that's kind of unavoidable. So yes, there's going to be lots of exceptions and trials that will disprove the kinds of things that I'm saying, but I think I'm going to talk about trends, and I'm going to talk about what's going on here and elsewhere using comparative methods. And I think this is what's actually going on in trials, even if there are differences or we can point to exceptions. And I think it's also important to be thinking about, in this vein, the quotidian trial, what goes on in the average, the normal and everyday trial, rather than the celebrity trials you might read about in the paper, because they're not representative of the system, and they probably they don't show the limitations of the system in the same way, though no doubt they often show limitations. Okay, so it's an overview, it's about expert evidence, it's about incriminating expert evidence. And I guess my basic contention is that the adversarial trial has failed when it comes to incriminating expert evidence. It's failed to regulate it, it's failed to be concerned about its value as evidence, and I'm going to talk about some of the ways it fails, primarily by looking at some of the rules and procedures and institutions that it's set up and hasn't really endeavoured to change over time. So I'll start off, and I'm going to say that we need a reliability standard, and that's as part of our admissibility criteria for the admission of expert opinion evidence, but I'm also going to say that that's not going to be enough. So I'm going to nuance that slightly at the end. And I'll start off by talking about the overarching principles or backdrop to the kind of the adversarial tradition in relation to the criminal justice system, but particularly the adversarial criminal trial, the accusatorial trial. And basically I think there are a few main kind of principles or overarching goals associated with the trial. The first and most important one is what's called, after Bentham, rectitude or accuracy. We're after truth in the outcome of the proceedings. We want the proceeding to produce an accurate result or to reflect a kind of factual accuracy. That's very important. And it's the most important feature, and indeed I think every serious scholar and judge that I know of would say that's the most important feature of the trial, to get it right. But it's not the only feature, and indeed historically, and for 1,000 years in England, people have spoken about this idea of we want to not set up a symmetrical system, but we want to set up a system that avoids a certain outcome, and that's the conviction of the innocent. So we're concerned, even though we want to get things right, there's a type of outcome we don't want to occur. We don't want to convict the innocent. And so you get these kind of phrases, they range from 5 to 1,000 in different traditions and at different times, about not wanting to, or it's better to let guilty people go free than execute or convict and maybe imprison those who are innocent. As part of and from that we have things like the presumption of innocence that's associated with that. We have differences or asymmetries in the burden and standard of proof that are applied to the particular parties. And we also have things which are further afield, such as prosecutorial restraint. A range of things which should be influencing that. And another value here, or principle or overarching goal, is that the trial should be fair. So after a procedure or an institution that runs things fairly, so that means that we want to do things like have certain entitlements, so that might be things like the witness or the accused can confront witnesses. We might want the use of evidence which actually has probative value rather than might kind of raise prejudice or in a way that might be unfair to the accused or is difficult for the accused to expose or challenge. And that will come up in relation to expertise again. Increasingly, there's another value associated with the criminal trial, and that is efficiency. And I guess over the last 2 decades, that's become increasingly important, that the trial should be efficient, and increasingly people seem to be looking at costs in way of kind of concentrating disputes to reduce the costs on the state of trials. And trials are only a small percentage of the, I guess, the criminal justice system in terms of most of the things are settled or resolved away from the trial. But there's this push. One of the things I will argue is that the current system is inefficient And by having a different arrangement in relation to admissibility, at least some trials will be far more efficient in the way that they're operating. And indeed, there may be fewer trials at some level, but probably only marginally fewer. But the trials themselves may be more efficient. Okay, so I'm going to talk about evidence, law and trial safeguards here. And I guess there are a range of rules and procedures and institutions such as the jury which have been designed to instantiate or institutionalise these kind of overarching goals of the criminal trial. So admissibility standards, discretions for the judge in relation to excluding evidence, the way evidence is expressed in court, so experts might be constrained in what they can say, even though they might want to say other things, they're told they can only say certain things, cross-examination, the ability of the defence to call rebuttal experts or their own original experts. Then there are warnings, instructions and directions to the jurors. Then we have a lay jury, so it's kind of independent from the prosecutorial arm in government in terms of the assessment of the facts. And then there's also appellate review. So we have all these kind of protections in place, and they're often used individually and or in combination to rationalise the admission of evidence, and including evidence that's not necessarily reliable. So let's start off with admissibility. The first thing I want to say about admissibility is that evidence to be admissible should be relevant. It should be logically relevant to the facts in issue. Now, one of the features of our current system is that there's necessarily no attention paid to reliability here. And so if you don't know about whether an expert can do the sorts of things that they claim, or whether they're better than another person, a lay person, or better than guessing, it's hard to know whether their evidence is relevant. That's a problem. It's hardly ever considered by judges, but it's undoubtedly a problem. They tend to ignore it, and I'll address the way they ignore it in a little bit later when I talk about discretions. Most of the expert evidence that comes into court is opinion evidence, and under the Evidence Act, and I'm going to talk about the Evidence Act because that's in place in New South Wales, Section 76 basically says you can't express opinions if they're being used to prove or support the facts contained in the opinions. It's prescriptive. You can't basically come into court and offer opinions. There are some kind of exceptions, some statutory exceptions, and the one we're most interested in is the one that allows those who have opinions based on specialised knowledge. So this is the one that allows experts to come into court and offer their opinions. It's a cumbersome section 79.1. It would be it was section 79, except Annie Cousins, I don't know if she's here, had too much influence, and so it's now section 79.1. There's section 79.2 and 3, which she was instrumental in having made part of our law. So section 79.1 doesn't capture the pre-existing common law in relation to admissibility, which was basically whether the evidence was seen, the opinion evidence of an expert was seen as necessary, whether the person actually had formal qualifications or experience in the area they're going to give evidence in, and whether that area was recognised or known to the law effectively. That's gone, and now, and I'll read it to you because I can't put it up, if a person has specialised knowledge based on the person's training, study or experience, the opinion rule does not apply to evidence of an opinion of that person that is wholly or substantially based on the knowledge. Now, that's not really going to help you, but there are basically three requirements here to give opinion evidence outside this covering the field prescription on opinion for these people: that they have specialised knowledge, that the specialised knowledge has to be based on their training, study and experience, and the opinion has to be wholly or substantially based on their specialised knowledge. So opinion based on specialised knowledge, based on training, study and experience. Now, all that's good, and I think people were probably happy about that. This rule, when it came into effect in 1995, was based on the Federal Rules of Evidence of the US from 1975, their Rule 702, which had some similar terminology as well, and I'll come back to say a little bit about that in a minute. Now, unfortunately, there has been very limited discussion about what specialised knowledge means, but the leading decision that we have in New South Wales, which had an opportunity to kind of develop and unpack this, was really, I think, unsatisfactory. It's the case of Tang. Now, in that case, the Chief Justice, or the former Chief Justice, when considering what the word specialised knowledge means, didn't really tell us what they mean, but said that we should focus on those words and I'm quoting, and we should not concentrate or focus, I'll get it exact, that we should not introduce extraneous ideas such as reliability. So I'm not exactly sure what the Chief Justice and the Court of Criminal Appeal were referring to here when they're talking about having a form of specialised knowledge which has kind of no part of its essence the need for reliability. And I think that's a problem, and it's a problem which has infected both the pre-existing law and that which has come after it. Now, I think it's significant that in the United States, when they came to interpret a similar clause in a 1993 appeal, this is Daubert, and it was followed up in the same way in 99 in a case called Kumo, when these courts were interpreting scientific knowledge and specialised knowledge, or other specialised knowledge. Both of those courts said it's the word knowledge that requires reliability, not qualifiers like specialised or scientific. So they were saying that the fact that the word knowledge is there means that we have to have reliability, and those courts have imposed a reliability standard on the admissibility of expert opinion evidence. We haven't. So I think Tang is quite unfortunate. So notwithstanding that we have a prescriptive rule, section 76, you can't express opinions. There's an exception, section 79, for specialised knowledge, or opinions based on specialised knowledge. Courts in New South Wales have gone even further and have invoked this other idea, which doesn't have any kind of basis in the Evidence Act, from what I can ascertain, and indeed it pre-exists the Evidence Act, which is the idea of an ad hoc expert. And in the areas that I've been particularly interested in studying, which are voice comparisons and image comparisons, so these are things like CCTV or telephone intercepts, where you're trying to work out whether the person's voice who's speaking in relation to an illicit drug deal is the person you have in custody. These types of evidence are coming into court, and there aren't necessarily people with specialised knowledge here. And so what courts are doing is they're allowing people like anatomists, they're allowing linguists and translators and police officers who are listening to the intercepts to come in and express their opinions. Now, these people don't have specialised knowledge in the comparison. They're being allowed in for expediency. I guess it's pragmatic, it's convenient for the courts and for the prosecution to admit this evidence, but we have no understanding of its value in terms of its probative value or reliability, whether the people can actually do these sorts of things. And it doesn't seem to have any statutory base. There's a rule saying you can't express opinions unless you have specialised knowledge, but these people don't have the specialised knowledge. I mean, you could have really contorted arguments to say that a person who spends time watching a video over and over has specialised knowledge in relation to that video, but that just becomes kind of absurd, and everyone can become an expert very quickly in that case, even an anatomist. Now, what I was going to do is I was going to show you an image here of one of these cases, and you'd be all you'll all be offended, I guess, I'd hope, at the really low quality of the images that are being relied upon, and what experts, or I should say that in inverted commas, what witnesses, often with very high qualifications in a field like anatomy, are doing. They're coming in to court, coming in as a professor of anatomy or with a PhD in anatomy, and then they're interpreting very low quality images, and often in terms of positive identification or individualisation, saying this person is the person in the robbery. Sometimes the people are wearing disguises, a stocking over their head, maybe a motorbike helmet, maybe you can just see a nose, and people are still making positive identifications. And in Tang, that was indeed the case. An anatomist was allowed into court to make a positive identification. She came in, and the quality of the image is very low. I'll put it on the screen here later on, so if you want to come down, you can have a look. She made a positive identification. The accused and the person of interest in a convenience store robbery were one and the same, to the exclusion of all other people in the world. Now, she's an anatomist, but you can give them that. She had no ability or method of overcoming the distortions in the images. She doesn't know how frequent some of these features are amongst populations or subpopulations that might be of interest. She was told by the police who they thought the person was, and was only given a certain limited number of photos to compare anyway. And it goes on and on. Now, and the court admitted this evidence. And in Tang, even though the judge said this witness doesn't have specialised knowledge in relation to the comparison of images, she's an anatomist, she'd spent time looking at the images, we'll let her testify. Comes in as an ad hoc expert. But we're not particularly concerned about reliability, we know from this decision as well. Now, you might think other features of the adversarial trial would offer protection, things like the mandatory and discretionary exclusions. This is where a judge has to balance the probative value of evidence against the danger of unfair prejudice to the accused. So this is a discretion, but it's also in certain circumstances mandatory. The judge has to undertake this balancing exercise. So the probative value, what is the value of the evidence, which goes to proof, as opposed to this incommensurable, the danger of unfair prejudice to the accused, that the jury might misuse or misunderstand or overvalue or defer to the expert in a way that they shouldn't. They have to make that decision. This has really no purchase in our system, and I mean it's used on the margins, but it's been eviscerated because what judges do in these trials is they say, we don't want to get in the road of what the jury's going to do. We'll defer to the jury here. They may accept that someone like this expert can do what they claim or is making a reliable assessment and that their evidence is valuable. And in that case, that's the value, the probative value that could be assigned to the evidence. And we're going to weigh that against the danger. If the jury decide that, then there's no real danger that they'll be misled by unreliable evidence because they've assumed it is reliable. That doesn't really make sense, but that's the kind of bizarre kind of reasoning that they get into here. And so rather than require these experts to come into court with methods that have been validated or where you have some knowledge of their accuracy or even undertaking some kind of proficiency test, what we have instead is judges just saying, well, we'll leave it to the jury because they may find that it's kind of persuasive and the dangers really don't exist if they find it's persuasive. It makes no sense. Other trial protections. Again, if we refer to Tang, one of the things that happens here is the expressions, the way the expert comes into court is affected. So rather than exclude the evidence on the basis of it not satisfying the admissibility criteria, rather than exclude the evidence on the basis that the probative value is low or unknown and the prejudicial effect high because we don't know if the expert can do these sorts of things, and we have empirical studies which suggest that juries defer to experts, especially when the conditions are uncertain, like in comparing images of unfamiliar faces, especially low quality images. They often will do things, they'll let the evidence in and say to the expert, okay, the evidence comes in, but you can't say they're one and the same. What you can say then is that you can see some similarities. And so what happens is the expert comes in and they've started to manipulate this already, so we're getting to see high levels of anatomical similarities, a terminology that's being used now, but that doesn't seem to have much of a basis in anything. And again, the evidence that we have seems to suggest that if an expert comes in and is offering an obviously positive opinion in relation to identification, the qualifications probably don't matter that much. So there's a whole series of studies by McQuiston and Sachs in the United States which suggest that it doesn't matter. So this is interesting because judges aren't very receptive to psychological or empirical research generally, but the evidence that we have in this area suggests that the kinds of qualifications and safeguards they're imposing on evidence don't work. But they continue on with this, implying that their intuitive feel of how evidence might be qualified is going to have some practical effect in the trial. And I have another slide here, which is a kind of nice comparative slide, which just shows you how unprincipled these kind of qualifications are, because no doubt the most reliable form of forensic science that we have today is properly conducted DNA typing. There's just no doubt about it. It's the most thoroughly researched by a long shot. It's not infallible, obviously, and I'm not to say there aren't limitations with it, especially interpretations of mixed samples and faint amounts, but it's represented in court or expressed in courts in probabilistic terms. So there's a database and we offer a kind of probability, whereas things like latent fingerprints, where we have a database but we're still uncertain about what matches mean and how strong that evidence is, and this research is being undertaken as we speak, or as I speak, the expert can come in and talk about a match being individualisation to the exclusion of everyone else in the world now and whoever lived. So you have a weaker form of evidence being allowed in and to be expressed in a stronger form, and the same for incriminating images. So it's very weak. We don't have any kind of validation studies to suggest that these people can do what they're claiming, and yet they're allowed to come in and say high levels of similarity. We don't even know if the things that they're claiming are similar are real or just image artifacts, but that's what is allowed. And voices are the worst. In relation to voices, you can come into court and say, you can, like fingerprints, you can listen to a voice and offer positive identification. And there's another slide which I won't show. It's beautiful research which shows how people don't understand the terminologies that judges and experts use as well. Judges don't understand them, jurors don't understand them, and experts manipulate them. Lovely slide. I can refer you to it if you want, email me. Cross-examination. Cross-examination can work really well, but it's not the great engine that everyone or people often suggest it is. It's really dependent on a few things. It's dependent upon a reasonably well-resourced and competent lawyer. It's dependent upon an expert, and maybe one that's not incredibly resilient. It's also dependent upon the capacity of jurors. So you have all these contingencies, and I think what often happens in my experience is that even when things are well exposed in cross-examination, it's not clear that they're appreciated by the fact finder. It's a real problem. So you can have a beautiful formal procedure and it goes nowhere. But I think that doesn't happen most of the time. Often I just sit in court and I struggle to stay still. So poor is the cross-examination, especially from the defence. They're strained in terms of resources and ability, and that's a system failure. But relying upon cross-examination to expose these things produces often the most superficial criticism, where you're looking at just kind of interests of the expert rather than substantial or sophisticated methodological issues. And it's not clear that they'd be understood anyway. So maybe they're sensible in a tactical way, but they kind of don't really get to the problems of some of these forms of evidence. The meta-analysis of the effects of cross-examination suggests, and I should quote this, this is a summary of the meta-analysis of all the empirical studies on cross-examination. It's unlikely that defence cross-examination will reduce the impact of the forensic expert witness's direct testimony. Rebuttal experts and defence experts. Well, again, these are another reason that you might allow evidence in. The defence have a rebuttal expert. First of all, there's a problem of experts. Historically, in areas like fingerprinting, there were no rebuttal experts available to the defence. Those things are changing, but they're still, again, it's still asymmetrical. The rebuttal expert, and people often talk in terms, and judges often talk in terms about a fair playing field or an even playing field, but different things are going on here. Normally, the prosecution brings in an expert as part of a really elaborate case. There's a range of different forms of expert and non-expert evidence supporting guilt, and often these people are guilty, there's no doubt about it. But what happens when you bring in expert evidence that's not reliable or of unknown reliability is that that can be supported by other elements of the case. So the case looks stronger, it has this kind of synergistic effect than it actually is. So it just seems like it's another piece supporting it, when in reality, often the expert who's offering the opinion, we don't know whether they can do what they claim, and they knew what the prosecution's theory of the case was anyway, and they made an identification based on one set of images or knowing the identity of the voice or whatever it is. Also, the prosecution witnesses tend not to look motivated, whereas the defence witnesses almost always look motivated. So you come in as an experienced forensic scientist in your day-to-day work and you offer an opinion, and then you go out and that's what you do in your day-to-day work. Whereas the expert for the defence is often someone who's come in a one-off or not very often. It's not their day-to-day work. They're often being paid separate to their normal work, or that's their profession, in a way that can make them look interested. And they're often not doing the sorts of tests that are being offered by the prosecution. They're just rebutting. Often they're offering incredibly sophisticated critiques of what the prosecution are doing or should or aren't doing and should be doing, but they don't have the sorts of effects, I guess, against the positive evidence of the kind of apparently impartial expert evidence that's part of this bigger case. And I think facilitating, and some judges, and this is kind of crazy in the sense, when they're considering the admissibility of evidence in relation to the prosecution's expert, will ask, is the defence bringing a rebuttal expert in? And if they are, that will help to support the admission of the evidence in the first place. So the fact it's fair, because both parties are going to have an expert, even though there's no expectation on the state to bring in reliable evidence to begin with. So this is shifting the kind of the balance, or undermining the burden of proof at one level, because suddenly the accused is obliged to negate evidence that probably shouldn't be there. Directions and warnings for the jury, another justification for admitting evidence into the trial. We can admit unreliable evidence and evidence of unknown reliability into the trial because we can tell the jury about the dangers of this evidence. Once again, almost all empirical evidence that I have seen suggests that these things aren't effective. The few studies that I know of where it becomes more effective are where they're kind of mock jury studies and where you just focus on one kind of evidence and try and train the jury up so that they'll consider it better, but that has nothing to do with what really goes on in a trial where you have complicated amounts of evidence, multiple directions. Sometimes directions can go for hours. So I think it's a very artificial way to go about this. Very confusing often. It's very hard to follow directions in a trial, if anyone's ever seen directions being given to the jury. I think they make the trial formally fair, so those looking from above, the appellate courts, it looks very fair, these trials. Because you look at what was said and so forth, although judges often make mistakes, understandably it's very complicated. But substantially they seem to do very little. And I think some voice work that Nera and Christy and I were doing, I think is a good example of this. Judges are often directed to take the jurors to the specific dangers in relation to evidence. So in voice comparison evidence, they might say things like, the fact that this person was identifying a stranger in a stressful position might undermine the kind of value of their evidence. And they might draw attention to features like that. What they'll never tell you, and this is really unfortunate, and a failure to engage with empirical evidence that exists, is that things like the level of accuracy and identification of strangers an hour after you've heard the voice is, for say 30 seconds, is something like 70%. After 3 weeks, it's down to about 8%. Having detailed information that the jurors might actually weave into their analysis might actually help with the assessment. Just being told that there are issues here, be careful, tells you nothing. And then when it gets to things like some of the cases in New South Wales where people are identifying people 18 months after a home invasion where they didn't see the person by being taken into a court and listening to them speak in a dock. These are old cases admittedly, but those were the sorts of things that were being allowed. Or one interpreter was allowed to make an identification 7 years after she heard a voice incidentally. They're scandalous, but a vague warning won't correct those sorts of things. I won't talk about appellate reviews, but they don't work very well for a range of reasons. I'm happy to take questions. Just so that you don't think these are complete ravings of a madman, in 2011 the Law Commission of England and Wales produced a report on expert evidence in criminal proceedings, and repeatedly it questioned the safeguards. And I'll just read one to you, one of their quotes from the report. So this is from about 6 weeks ago, it's just been released. Cross-examination, the induction of contrary expert evidence and judicial guidance at the end of the trial are currently assumed to provide sufficient safeguards in relation to expert evidence by revealing to the jury factors adversely affecting reliability and weight. However, it is doubtful whether these are valid assumptions. So there's no doubt there's a need for reliability. There's a great deal of unreliable evidence and evidence of unknown reliability coming into courts. This is expert evidence. And you've got to ask yourself, how does evidence that's unreliable or of unknown reliability, and I'm talking mainly about evidence where we can assess these sorts of things in a general way, how do they assist with the goal of rectitude? If accuracy is our most important goal in the criminal trial, how are they helping that? How is helping this evidence that may have no value and may have value helping that decision? And the fact that we can test many of these methods, I suggest means that we should be testing them or not letting them in. It's not good enough just to come in and say, I'm an expert, because the experts will ride whatever the courts will allow. So we need to be asking, can you do it and how accurate you are at doing it? Now, I just wanted to compare a few of the other leading common law jurisdictions to discuss what they're doing. If we can compare the United States, in 1993, one of the cases I mentioned before, Daubert, changed the playing field there and interpreted their rules, which were at that stage similar to ours, in terms of the need for reliability. Expert evidence has to be reliable to come into the trial. They put forward 4 criteria: testing, publication and peer review, known or calculable error rate, and general acceptance, and there's some discussion in the judgment about the need for standards and applying standards. So these are criteria that might ordinarily help the trial judge, reinforced in Kumo and extended to other types of non-scientific evidence. And then in 2000 their federal rules were actually modified so that from that point on reliability is statutorily enforced, or at least it's embedded in those rules. the need for reliability. I should say they're all civil cases, and it's interesting in the United States with the civil juries. These cases, I think my kind of socio-legal reading of them, I think it's one supported by the empirical evidence, is that judges were doing this to stop juries receiving evidence in civil cases at a time when there was real concerns in the US over litigation explosions and too much civil litigation. In Canada, to their credit, these judges are at least dealing with criminal cases, and in the year 2000 they said we're going to apply a Daubert style of reliability to our criminal cases. So in DD and LJ or JLJ, the Supreme Court of Canada, and particularly Justice Binney, said it's no good just allowing things to go to the trial and be worked out in terms of weight. We have to put more emphasis on admissibility. And then in Trockheim, most recently, I think 2007, the Supreme Court said that reliability is an essential feature of admissibility. Though the Canadian courts have struggled still, especially the lower courts, and they've struggled with admissibility in relation to grandfathering evidence, so types of evidence that have been allowed in for a long time. What do you do with those? If you've allowed this evidence in and it's not reliable, how do you respond? Do you suddenly disallow it? And then what does that mean for all the other cases? They're practical problems. And also evidence that's not obviously scientific. How do you manage that in terms of the kind of Daubert criteria? England and Wales, the basket case of the adversarial world, it allowed just about anything in until recently, and this report, and now they're saying we've got problems, and they're advocating the need for a reliability standard. They say it's nothing like Daubert, but it's exactly the same as Daubert in practice. So they're advocating, and they've got a draft bill in place from their report for a range of reliability criteria that have to be satisfied to allow expert opinion evidence into the courtroom. They're also advocating some things like increased use of court-appointed experts and very cumbersome way of appointing that, and more training for judges and lawyers. Okay. I think reliability is important, but I said I don't think it's the whole game and it's not enough, and I think it's not enough for a variety of reasons. The National Academy of Sciences recently produced a report on the state of forensic sciences in the United States, a damning report which basically says, apart from some chemical analyses and DNA typing done well, basically we don't know about the reliability of any of the forensic sciences involved in comparison or pattern recognition. Damning. And we don't know about it in America, and we don't have any special research over here that they don't know about. We don't know about it anywhere. So there's a problem with the science, but they also say, and this is an eminent committee of scientists, statisticians, engineers, biomedical researchers, a judge, and some lawyers, some law professors, and they say law has failed, and the legal profession and the courts are not going to fix this problem. So there's that out there. Also, there's been studies of judicial abilities to understand the Daubert criteria, and they've come up badly with those criteria. The studies about the actual application of the Daubert criteria, and they found that judges in the United States don't apply them. So they actually just use the traditional things of whether the person's an expert, whether they've got formal qualifications. They don't look at things like validity and reliability. The innocence projects in the United States suggest that their courts, at least, and there are many, many similarities, though there are many differences as well, especially from the defence, the quality of the defence, their courts struggle and have struggled, and appellate courts have struggled as well, with people that are not just not guilty, but are factually innocent. So these, in theory, shouldn't be the closest cases, and there's a lot of, I guess, problems with the forensic sciences in those cases. The interesting thing is that in the United States, and to some extent in Canada, where we come to admissibility, the judges tend to apply the admissibility criteria in an unprincipled fashion. They tend to apply it much more aggressively. They're not using the criteria, just being more exclusionary for a range of reasons to the evidence of plaintiffs in civil cases, so the plaintiffs don't get into court, juries don't get to hear the cases, but they don't apply it as aggressively to the forensic sciences and the state's evidence. It's an inversion of principle, because in theory the state should be a bit, or the court should be a bit more hands-off in relation to civil cases, and they should be more hands-on in relation to the criminal cases. They should be asking the state for evidence, especially where there's a reliability standard. I I made a beautiful comparative slide here, which shows the various standards across the kind of common law world. And basically the interesting thing from Canada, the United States, Australia and England is that whether you have a reliability standard or not, they all let exactly the same evidence in and basically allow the experts to say exactly the same thing. And it's not because all the evidence is reliable and satisfies the minimum standards in Canada and the United States, it's because none of those really make that much of a difference. They just let it in. Almost no jurisdictions exclude it. And that's supported by studies in the United States about different jurisdictions. Some have Daubert and some don't, some of the states, and that seems to be the consistent pattern there. So in closing, Daubert's not going to be, or a reliability standard is not going to be enough. I think what we can expect is more exogenous pressure on law and legal institutions. Reports like the NAS report, the Royal Society of Statisticians in the United Kingdom, a range of groups are actively intervening now to say, courts, you're making mistakes, you're doing things incorrectly. It's friendly at the moment. There's no reason that it has to be, and there's no reason that will be as we continue. And so I think courts, in terms of being in a rational tradition, having public confidence and legitimacy, they're going to have to start to respond to some of these things. Otherwise, they're going to start to look bad. It's going to look bad if you're a court and the NAS says, it already does look bad, you can't handle scientific evidence. You have to do something about that. So I think in Australia we can expect a reliability standard, but we can also expect it to make very little difference. I think things like training judges and so forth are really just tampering at the margins or filling with deck chairs. I think we probably need to look at new forms of engagement, and one of the things that I'm going to be trying to work on in the next couple of years is to set up what I'm going to call a multidisciplinary advisory panel, because of the acronym, and get a group of about 10 or 12 people like the NAS committee to look at particular types of expert evidence and to write very short accounts of the value of that evidence based on the existing research that's available, to offer to judges who are making admissibility decisions, because the parties don't ever do this sort of thing. They never refer, or very rarely do they refer to literatures or more than just some really superficial literatures or one or two articles, to actually sum up what's going on here, what the actual techniques or the expert can say based on the existing evidence as a way of offering advice. It's not for admissibility, the admissibility decision, it's just advice. The courts have to make the admissibility decision. And finally, I guess, in the longer term, I think, and that's a minimalist intervention because it really retains the existing system, it's just a way of offering advice, and we have to even think about how that can be received by courts, although one party will almost always want to bring it in. And the other thing I think will happen, and I'll end on this, is that I think in the longer term, the current institutions just can't continue. We won't have lay juries in exactly the same way we have them now, and we'll have to have experts kind of actively implicated in decision making, maybe with lay people and judges, but it will be different. And I think there's little doubt to that, although it's going to take a long time to eventuate. So I'll stop there. Thank you.